Evening and welcome to the March 22nd Board of Adjustment meeting here in Tarpon Springs, Florida. I want to call this meeting to order. Carrie or Allie, would you introduce who's going to be leading us in roll call this evening?
Sure. Today we have Paige Tillison. She's a member of our project administration department, and she is so kind to help us out to allow Kim to take some vacation. So she will be here doing or serving the role of secretary tonight.
Thank you.
Nice to meet you all.
Thank you for being here. Would you lead us in roll call?
Okay, we have Miss Rich,
Present.
Mr. Herbowski,
Still here.
Miss Simon,
Present.
and Mr. Grossman.
Present.
Okay, thank you. This evening, we do have a few people absent, and so we're so glad that Mr. Grossman is doing his first time as member.
Thank you.
So we welcome him. Now we're going to ask our attorney to explain a little bit about the quasi-judicial procedures and read the quasi-judicial announcement.
Okay, thank you. The matters before the City of Tarpon Springs Board of Adjustment are quasi-judicial in nature. In a quasi-judicial proceeding, the board's function is to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the City of Tarpon Springs Code of Ordinances. This is a legal decision regarding the application before the board. The board may only consider evidence that the law considers competent, substantial, and relevant to the issues arising from the application and the applicable code sections. Any and all persons providing testimony at this hearing are required to do so under oath. All persons testifying at this hearing must give their name, address, and must indicate whether or not they have been sworn for the record prior to proceeding with their testimony. All testimony and questioning at this hearing must address matters that are relevant and material to the issues under consideration based on the criteria established in the City of Tarpon Springs Code of Ordinances. If any board member has disclosures regarding the application, please make your disclosures on the record at the beginning of the hearing. That would include ex parte disclosures and voting conflicts of interest. If there is not a full board present at the beginning of the hearing, which there is not tonight, the applicant may request a continuation to the next regularly scheduled meeting of the Board of Adjustment. The following is the established procedure which will be followed at this quasi-judicial hearing. First, staff will present its testimony and evidence regarding the application. Then the applicant may ask any questions and cross-examine city staff and city witnesses. The applicant will then have the opportunity to present its witnesses and evidence, and the city may have the opportunity to cross-examine the applicant and any of the applicant's witnesses. Then members of the public opposing or supporting the application will be given the opportunity to speak for 4 minutes apiece. The applicant and the city may then present any rebuttal testimony and evidence and a closing statement for summary. Then the board will close the public hearing for discussion and consideration of the application. At this time, anybody who's going to be speaking, please stand to receive the oath. Are you the applicant? Yes. If you're gonna be speaking, you gotta stand up. Please raise your right hand. Do you swear to tell the truth on the matters before the City of Tarpon Springs Board of Adjustment this evening?
I do.
All right, thank you. Make sure when you go up, you indicate that you were sworn for the record.
Thank you. Tonight, we have before us application number 23-16, variance to allow a non-conforming lot of record to be built upon for the purpose of constructing a new single-family home. The location is at 1211 East Boyer Street. Now we'll hear from Allie in the city.
Again, Allie Keene, Senior Planner with the Planning and Zoning Department. Again, the subject property is located on the north side of East Boyer Street. It's outlined here in red on the screen. This property, as well as all surrounding property in the immediate neighborhood, is located within the R70A single-family residential zoning district. The Land Development Code states that if at any time the owner of a non-conforming lot of record owns adjoining land, the lots shall be combined to meet the minimum lot requirements. The applicants are here today requesting variance approval from the board to allow a non-conforming lot of record, which is lot 17. Here, the dotted lines are showing the historic lot layout, but to allow lot 17 that is under common ownership with lots 18 and 19 to be a separate buildable lot, and this is for the purpose of building a new single-family home on Lot 17. This is a look at the survey of the property. There is an existing single-family home. It's located mostly on Lot 18. There's a pool, a couple accessory structures, and a driveway on the property. The blue dotted line is representing the historic plat line of Lot 17 and where the applicants are proposing to follow if this variance is granted. The R70A zoning district requires a minimum lot area of 6,500 square feet, a minimum lot depth of 80 feet, and a minimum width of 60 feet. Lot 17, if it was split, is non-conforming in both lot area. It's only 6,350 square feet in area, and it's only 50 feet wide, so it's non-conforming in area and width. When going over the history of this property, something unique in this case is, according to the property appraiser, the single-family home that is on the property was constructed in 1922. This predates this property even being platted into 3 lots. It was platted officially in 1925 into lots 17, 18, and 19, and that's part of the Young Subdivision Deluxe. The first land development code went into effect in 1944. At that time, the lots in their historic plat configuration did conform with the zoning that it was placed into. But at some point in the 1970s, through a series of updates to the code and amendments to the land development code, these lots became non-conforming in area and width. As far as common ownership, it appears that lots 17, 18, and 19 have been in common ownership since the property was platted. And again, that predates the common ownership provision going into place, the first land development code going into place, and again, the house was constructed before the property was ever officially platted. This is just zooming out a little bit, looking at the historic context. It's a little difficult to see here, but all the orange numbers represent the plat lots that they originally platted. They were all originally platted at 50 feet in width and the same size generally as what the subject lots are. As the neighborhood has developed over time, some homes were constructed in the 20s all the way up till, I believe, a year or two ago that they were constructed. Some of the lots have been built at the original configuration of 50 feet wide, such as across the street from the subject property, and then several of the properties in the area are basically accommodate more than one historic lot, such as this one here and one to the north of the subject site. There are a couple of considerations with this application. First, there is an existing accessory structure and carport, which is shaded in orange here on the screen. If the new lot line goes into place, it potentially could create a zoning violation because it will create a side setback conflict. The R70A district requires a minimum of 7.5 feet. This obviously would have no setback. The applicant has agreed to remove that structure prior to splitting the property. The other consideration is the existing driveway, which is shaded in green here. Again, there's a land development code requirement that there's a minimum 3-foot side setback. So prior to this property being platted, the driveway either needs to be altered so it can comply with that standard, or they potentially could do a shared or common access easement that they could use for both lots. They could do that at the time of platting. So if the board chooses to approve this request, then we would recommend having a couple conditions added to the approval that reflect these. And in the preliminary staff recommendation, your staff report, we put some language together for you. With that, these are your review standards specifically for non-conforming lots of record, and I'm happy to answer any questions.
Thank you, Ms. Keen. Does any of the board have any questions tonight for staff's presentation?
Not at this time.
I do have just a couple. Are you offering the city's file on this matter for consideration by the board?
Yes.
And I do have a question. I understand from the materials that they're doing it to basically sell to a family member that separate lot. If it were all one lot, would it be permissible to do like a grandmother house or grandmother's, like, you know, what they call the grandmother's
Yeah, an
quarters?
accessory dwelling unit.
Yes, thank you.
Yes, they could. However, the code does have parameters. One, it restricts the size to 600 square feet. It also requires that the existing home be owner occupied, which in this case it is. They'd have to be under the same, no separate utility meters, and they have to have a restrictive covenant for that. So they could potentially do that, but it has some restrictions to it.
Also, was there something on that other side of the property? Was there an accessory structure on the other side of the property, and what was that?
I believe these are just some storage structures. I'll let the applicant touch on those. They're intending to keep 17 and 19 together as one property, so there's no potential violation by, if they were separating lot 19, they could potentially have issues because it's an accessory before primary.
And they're allowed to have multiple accessory structures?
In this case, yes. Yeah.
Any other questions for Ms. Keen? Okay, now we'd like to hear from the applicant. If you'd like to share anything with us, please come forward and share your name, address, and... Yes.
My name is Elizabeth Banasiak. Address is 1211 East Boyer Street, Tarpon Springs, 34689. I think Ali said pretty much everything. I just wanted to let you know that this is not to be sold to someone. It's just my son. He's probably gonna get engaged, and they want to live in the neighborhood. They grew up in this house, and so they decided, they want to stay. Right now, I'm letting them both live there, but I have another son, so I would like them to kind of go have their own house. So, and it's too much land for me to take care of. So I just thought maybe it would be a good idea to split it up and give it to them, and that way we can be close. So when they have kids, grandma's gonna be next door. And that's and like Ali said, we can demolish anything that's in the way, like the carport. We can even get rid of the driveway. That's not a problem. And I know there's some big trees on that side, so we can take care of that also. That's it, unless you have any questions to
The
me.
only-
Thank you for being here tonight.
Thank you.
Is there any questions for our applicant?
I think my only question would be, do you have consideration for a driveway? Because you don't want to do without.
Well, he can do his, after we put the fence, let's say that we can't split, then he's gonna start building his house. We're gonna put a fence between us, and then whatever he decides to do. I think for him, it would be easier to get in the front. I don't think he will need that driveway. And we never really parked. I would rather park in front of the house, so I don't really need that driveway.
And those driveway accesses would be part of the planning process at the time he goes to build
Yeah.
the house, and each lot is allotted a certain square footage based on property size. So if you did get rid of that driveway, I'm sure you could work with the planning department to get a different driveway for your own home as well.
Yeah, there's no garage back there, so I don't really drive. We don't really use that much. We just park the cars in the front of the house, not on the side.
Okay, does anyone else have any questions for our applicant? No? Hearing none, is there anyone from the public, or you, sir, would like to say anything? Okay, all right. And are we on Zoom tonight? Not Zoom, so no Zoom people. I don't see anybody in the hallway, so I'm going to call for public comment to close. Hearing no other questions or comments, we do have some recommendations from staff report of language that was put in our proposal. Any of you would like to make a motion?
Motion to approve with the conditions that the city has outlined.
Do I hear a second?
I second the motion.
Thank you. We have a motion and a second on the floor before us. Would our secretary tonight, please?
Mr. Grossman?
Yes, approve.
Ms. Simon?
Yes.
Mr. Herbowski?
Yes.
Ms. Rich?
Yes. Okay, your variance has been granted with those staff conditions, and thank you so much for being here. And you can get with city about the, whatever the paperwork they need for the seal of approval. Thank you. We do have minutes tonight from 2 past meetings before us that need to be reviewed and hopefully approved. We have 2 sets. We have the October 26, 2022 minutes and the December 14th, 2022 minutes. I believe I can take those 2 as a group, or do I need to take them individually?
You can, but I wanted to make a recommendation to the board to table the October 26th minutes. During the October 26th meeting, you did have a board member that declared a voting conflict, and that voting conflict form was not attached.
Okay.
So I would like to have the October 26th minutes tabled, if I could. And then I didn't have any changes or additions for the December 14th ones.
Okay, it needs to be tabled and not just something that can be attached later? Okay.
Yeah, no, that's something that needs to be attached, and you guys have to approve that as a whole.
Okay.
That's an important part of those.
Okay. Well, hearing that recommendation from our attorney, we will table the October 26, 2022, and if our recorder tonight could make sure that we put that on the agenda for next meeting to take care of that.
Okay, I would prefer that when it's tabled by motion.
Okay,
Oh, motion to table the October meeting's minutes
Thank you.
until we attach the appropriate document.
Thank you.
do we hear a second?
I second the motion.
Thank you, Joanne. All in favor, we have a roll call for tabling the minutes?
Mr. Grossman?
In favor.
Ms. Simon?
Yes.
Mr. Herbowski?
Yes.
And Ms. Rich?
Yes. Okay, we have now before us the November, no, I'm sorry, the December 14th, 2022 minutes.
Motion to approve the December minutes.
Do I hear a second?
I second the motion.
Thank you. Hearing a motion and second, could I have roll call?
Mr. Grossman?
Yes.
Ms. Simon?
Yes.
Mr. Herbowski?
Yes.
And Ms. Rich?
Yes. Thank you. We do have one additional item tonight. We have our staff attorney has, or I guess paid attorney, not staff, or contract attorney, whatever, has a presentation for us tonight to be done. And so I please accept your patience as we go through that continuing education for our team. She said it will last about 15 minutes, and since we're still doing well on time, I think that'll be fine, so take it away.
All right, thank you so much. And, I did want to make sure this was on an agenda that wasn't exceptionally full so that we kind of had time to go through it. And as I go through it, if you have questions, please don't hesitate to stop me. I don't mind, okay, to stop and talk about something that you might want a little bit more information on. Because this presentation is meant to be a higher level overview, because each one of these topics can be broken down into an hour-long CLE type presentation all by itself. So these are very deep topics, and what we're doing tonight is just a higher level overview, okay? So this is all on government in the sunshine basics that I kind of use to educate public employees and public officials with respect to their duties under the law. And the first thing that I always like to include, particularly for elected and appointed officials, is your oath of office. And I like that because it's a good reminder that, you're not doing this just as a private citizen. Once you take that oath, you do become a public official, and you are bound by these rules and laws, and you have to act accordingly, as well as, what's in the charter, where it defines what your actual duties are, and in your in the ordinance that establishes your board, where it defines what your duties are and what your responsibilities are to the community once you take office. Also, too, whenever I have to have a conversation with somebody and hand them their oath of office, it's probably not going to be a good conversation. So I always like to remind folks of that, because that is something that you should take very seriously, is what you're promising to do when you enter into office. So the next page, page 2, slides 3 and 4, is what is government in the sunshine? And some of the basics that Sunshine Law provides is both public access to government action and how the government is making its decisions and what decisions they're making, and it provides a high level of transparency. The real intent of Sunshine Law is as a tool to fight corruption in government, which is what makes it so important. It gives that capability because you are public servants, that the public is there and can be present and can know and understand the decisions that you're making on a daily basis. It does stem from the Florida Constitution and then was codified by the legislature in Section 286.011 Florida statutes. And there's 3 basic requirements. The first one is that the meetings of public boards or commissions must be open to the public. There must be reasonable notice given of such meetings, and minutes of each of the meetings must be taken. And then we're going to talk about each one of those sort of in turn here as we move through the materials. But the first sort of threshold question that I like to talk about for Sunshine Law is what constitutes a meeting, because most people think that the only thing that constitutes a meeting is a gathering like this, where we're all here, we're on a dais and we're taking official action. But under Sunshine Law, it only takes 2 board members to be present to have communications regarding official business in order for it to be a violation of Sunshine. And it's discussing any matters which will foreseeably come before them for formal action. I also do want to point out that this is specific to members of the same board or body, right? So you all cannot talk to each other, but you can talk to the Board of Commissioners, right? The one thing that I would discourage, though, because your board is a quasi-judicial board, so that means if you approve a variance that then has a site plan that ends up going before the PZB and the commission, right, and then you've talked to a PZB member or a commissioner regarding that application, then that individual is going to be required to make that disclosure on the record at that hearing that they had this conversation, the context of the conversation, and then provide an affirmation that they actually are going to make that decision based on the information that's presented in the hearing, right? So that's the bigger drawback. Is it a Sunshine violation to talk to them? No, but then it does create some conflicts when it comes to quasi-judicial proceedings. The other thing I like to point out is a writing reflecting views on a particular matter, right? And that seems very broad and very vague. So when you think about it, it can be a memorandum where you're preparing a memorandum that says, this is my position on this issue, and then sending it out to the board, right? That's what's called the one bite at the apple rule. You can make that, you can do that, you could put something out there, but then when a dialogue comes about where there's a back and forth, that's where the Sunshine Law violation happens. So if you put out your position paper, then Commissioner B puts out their position paper, now you've created a conversation outside of the context of a duly noticed meeting, right? And you now it's still a public record one way or the other, right? But when you create that dialogue and start that dialogue, that's where you're going to run into the Sunshine violations. I will typically discourage, almost always discourage, even taking advantage of that one bite of the apple rule, because it just invites that conversation, and you really don't want to foster that, because if there is a Sunshine Law violation, then it will nullify any decision that you do make on that particular topic. It will be like you never made it at all. It's called void ab initio, void from the beginning, right?
I have a question for you.
Mm-hmm.
If one person puts out something in writing,
Mm-hmm.
and then later on, days later, or the second person puts that makes it a conversation, is the first person held accountable because they didn't know it was going to be a conversation at the time they made the writing?
Well, that can depend, right? Because it can depend on how they style it, because if they do style it in a fashion that invites that conversation, the court could make a finding that there's that intent there. However, usually I find when people do something like that, it really is just to do just that. Say, this is how I feel about this topic. I don't think it's going to change, or whatever the case may be. But you also have to remember, you all being a quasi-judicial board, you can't make those statements ahead of an application, right? Because that means that you're not basing your decision on what's being presented to you at the hearing. I would say that a lot of the position papers that you see kind of out there will usually focus more on legislative type actions versus decisions like you all make on this particular board.
Yeah,
But people will be using Facebook and things like that, so
Yes.
they could
See,
make their opinion
and,
known.
and Facebook creates a whole lot of issues. That's not the only medium that people use that. You know, a lot of people have blog posts and message boards and things like that. All of those forums, you know, social media forums, web forums, things like that, invite that back and forth conversation outside of this type of an environment. When you're talking about public, you just have to have it set in your mind that when you're talking about public business and you're conducting public business, it needs to be here.
I can see one, I've been on the Board of Adjustments not as long as Mr. Habowski, but several years now. And there's been one application that has come before us during my term twice. And there may be in the next year that same thing coming back. At the time, I view it not as a conflict of interest if I'm hearing the same application
Correct.
3 different times.
Correct.
But I am getting some stronger feelings, like I know Mr. Habowski probably would when you're hearing the same story
Right.
and now it's 6 years. You know, so how do you navigate those strong, passionate feelings where we might have a position like, don't even come in this room, you know, because, you know, I'll try to be as impartial as I can, but it's getting more difficult that 3rd and 4th time you come before us. Do you have any words of wisdom on that scenario, since it might happen in
It
this
might.
next year?
Right, so once they have an application denied, is there anything in the code that says they can't apply for another year?
Well,
or
this
another
would
2
be where it
years?
was approved, but then they have a time limit, so they have to come
Expires.
back. And they
Yeah,
have
it was
to come
extended,
back.
but they still
Extended.
haven't built.
Right, they still haven't.
swore up
And
and
so
down he
that's
was
what
gonna
they
build.
swore
The
up
first
and
time he
down,
swore up
they
and down the
swore up
second
and
time.
down, and now it's like, we're getting to that ticker where it's going to expire again. And if
I
those
drive by
people-
there all the
I
time.
know,
There's,
I know.
there's nothing there.
I know, that's right. And you're going to have Jackie, who's our chair, absent tonight, but she also sat in those.
On that
where you
hearing?
hear the same song and, you know, and after, I'm just,
Right,
it's not
yeah.
conflict, but in some ways, we're not feeling real good if they want to apply again.
Well, here's the thing, is that they have the right to apply as many times as the code allows them, right? So if they can't apply for like another year, yeah, she's looking it up. I think, and what do they have, is it 6 months or a year?
I think it was
To
2
build,
years.
to
It was
build?
2 years and then 2 years.
I'm gonna double check on here. I don't want to
Is
misquote
it
another application.
Each time it's
Okay.
renewed, is it the full 2 years?
Okay, yeah, so, I mean, you can hold people to those timelines. Just because they didn't do what they were supposed to do doesn't mean that you know, you have to do that, right? So that is something that's within your discretionary authority. You gave them the variance, you gave them the amount of time to build what they said they were gonna do, and then they didn't do it. That really is on them.
And so when they see 4 of the same 5 or 6 people there, they can't say it's a conflict to have the same, okay.
No, it is absolutely, that is not how conflict of interest
Okay.
rules work, because I will talk a little bit about voting conflicts a couple pages down, but that is not what would constitute a voting conflict under the Constitution or the Ethics Code. So you are here, by virtue of your seat on this board, you are vested with that authority to make those decisions unless something would inure to your private benefit or the benefit of one of your family members or your business. Right, so those are the things that will conflict you out, not the fact that you had to sit here and listen to that same presentation multiple times. That's not a conflict.
Thank you.
I have the code.
Okay.
So yes, variances are basically applicable for 2 years.
Okay.
They have 2 years to, basically, for a building permit for construction has been issued, so the permit is issued. The variance does not expire as long as it meets the plans and the building permit's been issued. And then basically they are able to in writing at least 30 days prior to a scheduled expiration date. It says that the Board of Adjustments may grant one 6-month extension provided proper public notification mailing has been given. So you can, that's for an extension. So say that all goes away, I assume that they would be able to potentially apply for a new
Right.
application.
Do you charge different fees for an extension versus the application, or do you even charge any fees, do you know, for an extension?
That I'm not sure. I'll have to look at her.
There is a high probability because, that you would charge higher fees for the initial application because of the direct mail notice that has to go out.
Right.
Yeah, so, you know, it says you only have to grant one extension.
But then they can apply completely over
They
for a
can.
brand new.
Ally, do you
and
know what
that's they
happened to
did
that
the last-
property?
And they have to pay for that.
Last time
Yeah.
it was a
It's
new.
Peninsula and Gulf Drive.
Yeah.
It's right by the park.
I don't know if I was
You weren't
staffing the
here
board
for
this
that?
time.
Here,
I don't
Okay.
believe so.
Yeah, it's
No,
a
I
very
don't know.
odd-shaped lot.
Okay.
And the neighbors, a lot of neighbors came in
came
opposition
and
to
it
it.
was
Okay.
like this
Yeah, I
big
don't recall that. I must have not been on staffing the board at that time, but if they came back, we would, one, look and see if they qualify for an extension. It sounds like they probably would have to do a new application at this
It was a
point.
new application. The last time, I don't think they qualified for an extension.
And I don't
think it
recall
was-
the detail. I mean, it might be 3 times he's been here. Because it was, I think, Regina was with us the first time the guy showed up. We were upstairs.
Really? That
Yeah.
long ago?
Oh, a million years
Stay
ago.
tuned. Stay tuned. Well,
He did. He showed up upstairs. So that was,
Okay.
yeah, that was a
All
long
right.
time ago.
Interesting.
I mean,
I have
what
not
year
heard
were you
anything recently
working
about
as our,
this.
our board attorney? What year was that?
I would imagine that would have been around 2012, 2013,
Okay.
so almost 10 years ago.
And that was when Chris Alahousas was chair.
Yes.
Yeah, that was when they first came around. These guys been here 3 times.
Okay.
Okay, just FYI.
Anyway,
Good-
it's
good to
got to be
know.
due to come back soon.
So you're expecting visitors,
Yeah,
is what
yeah.
you're saying? Okay. The other thing, going back to what constitutes a meeting, you have to remember text messages, telephonic conversations, also emails. Those can all be meetings under the Sunshine Law. Now I'm going to talk a little bit about what open to the public means. It means that the facilities that you're having your meeting in have to be accessible, so ADA compliant and all of that, and then also adequate for the size of the crowd that you're anticipating. And I like to use the example from when I was on the Pinellas County Local Planning Agency. Sometimes we would have issues come up because they had a much smaller commission chamber there than you all do here. So if they were expecting a large crowd, they would actually have to move us sometimes to like the St. Pete Epicenter or the Largo Public Library to hold the meetings, just so they could handle the number of people that were looking to attend that particular meeting or hearing. One that keeps coming up in multiple jurisdictions right now for some reason is the no inaudible discussions. A lot of times it can be very tempting to turn to your board member and say something or ask a question about an application. You have to remember that that kind of defeats the purpose of making sure that the public knows and understands the conversations that you're having about what's before you. Also, too, the public has a right to be present and to be heard. So that right to be heard was actually written into the statute, I want to say in like 2011. They sort of elevate it to require that you put that on the agenda at any meeting where there's going to be an official action taken, and that's kind of been the law of the land for almost 15 years now. The one item that I didn't really talk about is notice and how much notice is required. The law actually doesn't define exactly how much notice you need to provide for a meeting. You all are in a little different situation because for the Board of Adjustment, you have to have those direct mailed notice to properties that are within a particular radius. So there's always going to be that aspect of the notice that's required for your board, but just the general posting of the agenda and all of that, the law just provides that it has to be reasonable. And usually that's going to be defined as nothing less than 48 to 72 hours prior to the meeting, right? On that next page there, page 4, I have the exceptions to sunshine. I will say that none of these are really going to apply to your board. These are all exceptions to sunshine, you know, the shade meeting and the shade meeting requirements. Those are all something that are going to be within the purview of the commission. So that takes us to our next section, which is public records law. And that's also part of the Florida Constitution, so I have that cited there. And then there's extensive regulations regarding public records, the handling of public records, and exemptions to public records that are contained in Chapter 119 Florida statutes. Then that next slide down, that has the statutory definition of what constitutes a public record. And it's really meant to capture everything, anything and everything, whether it's an audio recording, whether it's a digital recording, a photograph. It's not just paper and documents and digital files. You know, it's any material that is made to communicate or formalize knowledge. So if you go to the next page here, page 6 with slides 11
Pardon
and
me
12.
1 minute. I do have a question about, since our decisions could be appealed to a higher court, couldn't we also need an executive session or a shade meeting to discuss things with you? Or whoever's litigating?
No, because when they sue, they don't sue you, they sue the city. And so it's the governing body that then has to handle that lawsuit and settle it and take those actions on
So
behalf of
the
the
Board of
city.
Commissioners would always be in that?
Correct. That's
Even if
always
it
gonna be the
involved
board.
one of our
Yes.
decisions?
And the statute's very specific about that. So not only does the statute that governs shade meetings lay out like all those requirements, it specifically tells you who has the authority to attend those meetings, because it's not anybody and everybody, right? It's the governing body, it is the chief administrative official, and then the attorney for the agency. Those are the people that have the right to attend. There shouldn't be anybody else in those shade meetings or executive sessions.
Okay, thank you.
So here on this next page, page 6, I have a little bit of a better breakdown of the definition of a public record. And this actually comes from case law, and it's any material prepared in connection with official agency business intended to perpetuate, communicate, or formalize knowledge. So I would like to say that, you know, when you do see a lot of things that are posted on social media, particularly if you're posting them as a board member, then that becomes your record to maintain, right? You know, the city has their social media accounts that they run, right? And then if you post something about this board on your social media, it then becomes your responsibility to preserve that record, and hopefully when you leave office to give that record to the city so that they have it and can maintain it after you leave office. And that would be true too for any additional emails or things that, you know, you may have as a public record that aren't located on the city server. The other thing that I think is incredibly important to remember is that when you do receive a records request, there's a couple things you can and cannot do. The first thing you should absolutely do is notify the city, right? And the city's records custodian is the city clerk and the city clerk's office. They are considered to be the official records custodian of the city. However, if you possess a public record, you are the custodian of that record, right? So you're still responsible for that. However, it is imperative that you let the city clerk know that you received that request and let them help you answer it so you can make sure you're answering it appropriately. There's a couple things too that have been used over time to kind of do a little gotcha to cities. And there's some rules in place, like you can never ask the identity of somebody who's requesting a public record. So if you get an anonymous request from some email address you don't know, you still have to honor it, and you cannot inquire to that email address who they actually are, right? The other thing that you cannot do is you cannot ask why they want the record. The law considers the reason that they want the record irrelevant because it's a constitutional right to have access to that record unless there's a qualifying exemption to giving them the public record. So there's two kinds of exemptions. One is just a general exemption where you don't have to give over the record if you don't want to, and then there's another kind of exemption that is for confidential information. Confidential information cannot be released. You see that like a lot in police records, particularly if you're dealing with like victim statements and things like that. So not really necessarily something that's going to apply to your board, but confidential information can never be released. Exempt information, it's sort of at the discretion of the city whether or not they want to release it. And if there is an exemption, you do have to respond to the requester in writing and cite with specificity the exemption that you're claiming by reference to the statutory provision. So there's a lot of technical things that have to go into that response if you are going to respond to a records request, which is just another reason why I would suggest you have the city help you.
Yeah, if someone were to request records from us, it would have to be directly related to our position on this board, right? Not just because we are a board member. It would have to be involved in that or not.
So they could ask you for any record, right?
I mean, I know the
But
commission's
because-
going through
right,
that
yeah,
now.
but they can ask you for any record you want, even if it's not directly related to your board. If it's related to city business, they may just know you as a public official. They may not, a lot of times citizens don't know the difference between, a board member on the P and Z or a board member here. It's like all the same to them a lot of times. They don't necessarily understand the nuances of this board handles this kind of business and this board handles that kind of business. So if they do ask you for something that's not relevant to your position, it just becomes that much more important to forward that request to the city to let them handle it.
I have a question. So, if somebody is requesting a public record, I would assume that most of us are getting our public records from the city.
Yes.
So, if somebody's requesting us, we can just refer them back to the city. So I don't have any private public, I don't have any, well, it wouldn't be, I guess I'll talk to Martin, but I don't
Right.
have any public records that are unique to me. They all came from the city, and that should end it, right?
Yes.
How would we
I-
have a
I would-
public record in our possession that the city wouldn't have?
To the extent that somebody contacted you, a citizen or an applicant may have sent you an email, somebody who's objecting to an application can send you an email. There can be a number of ways, but if you receive something like that or have something like that and then you forward it to the city, well, then they have it and they can respond on your behalf. So if you do get things like that, just sending them on to the city so they can be put on the city's database, and then that way they're available to respond to records requests that they receive. So, all right. So any other questions on public records before we move on to the ethics? Okay. Florida's ethics laws for public officials, I always like to put the motto there from the Florida Commission on Ethics. That's also in the Constitution. A public office is a public trust. The ethics laws are set up to ensure that the citizens receive honest services from public servants. It's found in several places, including the Constitution, Article 2, Section 8, and then also Part 3 of Chapter 112, Florida Statutes, contains Florida's ethics laws. And also there's the establishment of the Florida Commission on Ethics, which governs ethics violations, and we're going to talk a little bit about their role in all of this. Going on to the next page, Amendment 12, I actually wrote a law review article on this. This Amendment 12 was a part of the 2018 election, and it received 78.6% of Florida voters voted to strengthen the constitutional provisions regarding lobbying restrictions and regarding abuse of public position. That's over 6 million Florida voters that thought it was imperative to increase those standards and to pass that particular amendment. So what that actually says is the lobbying restrictions prohibit municipal officials for 6 years from coming back and representing individuals or lobbying for a particular position before the body that they left. So 6 years from leaving office, you can't go back then and represent people for compensation before your previous agency. Abuse of public position, it follows the guidelines from misuse of official position, which has been a long codified prohibition in Chapter 112 Florida statutes. And basically it says that you can't use your public position to gain a disproportionate benefit. And we're going to talk a little bit more about that in a minute. But the abuse of public position, you can see there are some additional provisions that were in there that required the legislature to do a couple things, including defining what the disproportionate benefit rule would and how that would apply. So they enacted Rule 34.18.001 of the Florida Administrative Code. That's on the next page, page 8, and it goes through 6 factors there that the commission uses to determine whether or not something constitutes a disproportionate benefit. And they also established the intent requirement, which the intent requirement that they look for is not like malicious intent or anything like that. It is intent that is inconsistent with the proper performance of public duties. And that is the intent requirement that needs to be met in order to show a violation. So then under Chapter 112 Florida statutes, I like to break that down into 4 different sections there. So I have prohibited conduct, prohibited business and employment practices, financial disclosure basics, and voting conflicts. So on the next page, under prohibited conduct, we have solicitation or acceptance of gifts or honoraria, unauthorized compensation, again, that misuse of public position, and disclosure or use of certain information. So with gifts and honoraria, you can never take anything that is being given to sway your opinion or influence your decision-making. Typically, gifts that would be under $25, there's no reporting requirement. But anything that you receive that's higher than that, particularly anything over $100, there is a mandatory reporting requirement where you have to fill out forms regarding where you got it, who gave it to you, why they gave it to you, all that kind of fun stuff you have to fill out, right? The unauthorized compensation is, if you're receiving something of value for an official decision, kind of starts to look a lot like bribery, and there's another statute that I provide you later on in the materials on that. So the misuse of public position, we already talked about how that relates a little bit to the abuse of public position from the constitutional amendment. What's important to note is that the statutory provision is much more broad because the disproportionate benefit cannot be for the public official or others. And so that's a very broad or others. That means that you can't be having that to benefit anybody else. You can't be making the decision to benefit somebody. You have to be making your decisions based on the merits of what's before you. So then we have prohibited employment and business practices. We have the dual office holding prohibition, which is a constitutional provision. We have doing business with one's own agency. So you all cannot do business with the city of Tarpon Springs because you are public officials of the city. Anti-nepotism, you guys aren't really going to have much to do with that because you don't appoint or employ anybody on this board. You also cannot have conflicting employment or contractual relationships. That would sort of be somebody who was also an employee of the city, then being also a board member for a board. That in most instances is going to be a no. The dual office holding, you are a final decision-making body, so you do not have the luxury of holding other public office. You're prohibited while you sit on this board from holding any other public office, state or federal. And you also would be subject to the resign to run law if you wanted to run for another office. Next page, I have the voting conflicts. So that's governed by state statute. I have their section, Florida statute, section 112.3143. That disclosure is required. You do have to disclose at the beginning of the application. Then you have to fill out the state form, and then that state form has to be attached to the minutes. So that's all in state statute, which is why I had you continue your minutes, because it didn't have the attachment that's required under state law. So that can be a very big issue, right? The other thing I like to point out here is that you actually do have a constitutional duty to vote. You can't, just for any reason say, I'm going to abstain from voting on this. It has to be something that's a qualifying legal conflict for you not to vote on it. So requesting an ethics opinion from the Florida Commission on Ethics, public officials and employees are required to request opinions. If there's ever something iffy that's coming up and there's not clear-cut opinions already in existence or case law already in existence, you do have the ability to, before you take action or do something like that, to request an opinion. It has to be requested in writing. I will always highly suggest that you don't do the writing on your own, that you have either myself or another attorney assist you with that particular decision. And what you're going to be putting in that writing, because it can have a very big effect, because the decision that's then rendered and the opinion from the commission is binding on everybody, not just your community, everybody throughout the state. Same thing with the Attorney General's opinion. Filing an ethics complaint, this anybody can do. So you have to be a public official or employee to request an opinion, but to file an actual complaint, Anybody can do that, and it has to be in writing, and it does have to be signed and notarized. The Florida Department of Law Enforcement and any state attorney's office can also make referrals. They are the only agencies that can, as an agency, file a complaint. Otherwise, the complaint is supposed to be individual.
Can I ask, can I
Yes.
just back up 1 second? When you said that we cannot hold any other,
Public office.
what about a notary?
That would not be considered an office, a public office under the state constitution.
Good.
That's a threshold question, right? And that's the first analysis that they'll do, is whether or not each position constitutes an office for the purpose of the Constitution.
Okay.
So the Board of Commissioners, they voted to file ethics complaint against Commissioner Carr. How did they do it as an individual if they were as a body? Do you know if Trask did it? Did he put in his own name?
That would likely be, if they directed him to file, that would be the only thing, and then he would have had to have personally sworn to that, which I would never do as an attorney.
Wow, yeah.
So, I mean, that's
I don't know
not, I would not consider that to be my role. You know, ethics complaints are individual and individualized. So I'm not really quite sure how that proceeded
Okay.
that way, so. And it was before I was here.
Right,
so.
thank you.
The investigation, so once the investigation is commenced, it is confidential up until there's a decision by the Ethics Commission. They get the initial complaint, they give everybody the opportunity to respond. A lot of times they'll come and do investigations, and people will have to give sworn statements and things like that during the course of the investigation. And then the investigator will make a recommendation to the commission on whether or not there's probable cause. And then sometimes the individual, if they don't like the recommendation, can then request a full-blown evidentiary hearing before the Commission on Ethics. They do them in some places around the state, but mostly up in Tallahassee. And then the penalties that are adopted are down there on the bottom. And they kind of range, and they will range depending on what the violation actually is. They can include impeachment, removal from office, suspension from office, public censure and reprimand, forfeiture of no more than 1/3 of his or her salary per month for a period not exceeding 12 months, a civil penalty not to exceed $10,000, and restitution of any pecuniary benefits that were wrongfully gained. There has been several times the suggestion that that $10,000 figure be increased to $100,000 because the same rules apply to the state legislature and state office that apply to county commissions and municipal boards. And when you start to get into some of those higher offices, then that $10,000 doesn't always seem like that much of a deterrent. So they have been looking to increase that. That, by the way, I think has been the penalty since the 70s or 80s. So you can see, you know, it was meant back then to be a much bigger hammer, and it's just not so much of that big hammer anymore. So then on the next page, I do have the penalties for violation of sunshine law. Those are second-degree misdemeanors. So if you willfully and knowingly violate sunshine law, it is a crime. There has been a little bit of an uptick across the state in prosecutions for these. You know, for both this and for public records, because public records violations are a crime too. And again, those fines seem a little low, like the $500 figures seem a little low. That's really not what I would be worried about when you start getting into defending these. I have seen the attorney's fees in the hundreds of thousands of dollars, even as much as $720,000 in attorney's fees that were awarded in some public records cases. That actually for a while throughout the state became a pretty big business, where there were certain groups that were just systematically hitting cities for public records violations because the statute provided for automatic attorney's fees. But now there's some things that cities can do, like designating a specific records custodian and some other things that can help alleviate that burden of the types of attorney's fees that a city would be faced with for public records violations. The other thing too to remember, particularly like in public records and Sunshine, so there was one case that I like to brief that was out of Jacksonville, I believe. And in the Jacksonville case, they had two commissioners that would talk for hours on the phone. And they couldn't prove that they were actually talking about city business, or government business for their entity. But they basically said, common sense dictates that, they weren't talking about scheduling matters for an hour and a half. So, and then also, too, there have been some cases where they have actually got people on the other side of it for perjury, for saying that they had no communications and signing affidavits and giving sworn statements and testimony to the state attorney, and then going back and seeing, oh, the records reflect that these two people were actually talking. So if they can't get you on one violation, they are starting to look at the other just to make sure that there's a sufficient deterrent, so that these aren't something that are in name only.
I have a question back on the ethics penalties.
Yes.
It says at the top, impeachment, and then removal, and then suspension. So my recollection is impeachment is impeach means accused, right? So is that just a formal accusal of them? Because the other things are the removal or suspension, so what would?
So the governor has the ability to remove. And usually and there's some qualifying things in state statute and in the Constitution that talk about when he can exercise that authority, right? So that's one of the big differences between impeachment. Impeachment, you can think of it more like of something where there's that procedure that's put in place, like a recall election or some of those types of things, where you're following a given procedure to impeach somebody for their bad acts in office, right? So, all right, now moving on.
Then City of Clearwater?
Me? No.
I was just thinking, their mayor, stepped down during that meeting this
I
week.
heard about that, yes.
So I'm sure someone's going to go after them for sunshine law. I'm sure there was a few conversations after,
That's-
and I heard they're having a special called,
Election?
no, just a special called meeting.
Oh, okay.
So
They're
they
going to
can
help
talk
appoint, they're going to
about-
appoint
Yeah.
Somebody, yeah.
in-house.
Probably.
So-
Or if they can't come to an agreement, then they'll have to go to an election.
So I'm sure that that's going to be governed by what's provided in their city charter, because charters all have different ways of filling vacancies. That it's not something that's uniform. It's distinct to every community. There's some standard ways that you can kind of talk about, but a lot of times it'll depend on how long they have in office. And if it's an extended period of time that's left on their term of office, then some charters will provide that you're required to hold a special election. So criminal conduct in office, this is something that, we really just don't see a lot, so I like to kind of highlight some of the state statutory provisions. This first one here is false official statements. And that's, nobody can give you something in writing that they know is false and is intentionally false in order to sway your position one way or another, right? So that can be a big deal. And that's something that sometimes, you actually do see somebody's gonna put like all this stuff in there, and say things that aren't true. We have these testimonies for quasi-judicial hearings are under oath for a reason. The gravity of what they're saying, that they're giving you information, needs to be impressed upon the public, that they do have a responsibility in these applications to give you appropriate and accurate information.
And we did ask that once too, I think, when we thought the person was basically lying to us. And we even asked the attorney, I think, at the time, what do you do when, but they took the oath and they gave the testimony and.
Yeah.
But you're
It's one of those situations, you cannot control the actions of others.
Yeah.
So you can give them the information that they need, but you can't make them do what you do and do not want them to do, so. Next page, There's actually a couple sections in this chapter 838 that deal with sort of public officials and public misconduct from public officials, and I like to include this definition section here. I know it's very, very tiny, and there's a couple ones in here that I kind of have highlighted. One is the definition of the term benefit, which really is any commission, gift, gratuity, property, commercial interest, or anything of economic value not authorized by law. That's important. Also, the definition of harm for the purposes of this statutory section does include pecuniary or monetary loss or disadvantage in addition to actual injury. Then also the definition there of public servant, which does include all executive and government employees and officials, right? So down here, I have the section on official misconduct. And I like to talk about this one because it does talk a little bit about falsifying information, like if someone were to intentionally alter a public document and a public record in order to make it reflect something else. The destruction of public records is something that is very precise too, because the state, the Florida Department of State Division of Library Sciences publishes a records retention schedule, and it has a whole classification of this is what the record is, and then this is how long you're required to keep it. And then when a public entity does destroy records, they're required to report and file with the Florida Department of State what they destroyed and all of that fun stuff. So it's no small thing to destroy public records. And then the next one is the unlawful compensation on the next page, or reward for official behavior. That's really essentially bribery, and the bribery statute there for your bedtime reading. And then on the next page, I have corruption by threat against a public servant. And I like to include that because it is a special crime for anyone to ever try to threaten you in your official capacity in order to sway your decision one way or another. That is a crime, and it is certainly something that should not be tolerated. And then the last one there doesn't really apply
Prosecute
to you.
that, you call the police?
Yes, you would have to file a police report for that, and then it would be referred to the state attorney's office. So, and then the last one doesn't really apply. The disclosure or use of confidential criminal justice information is really more when you're dealing with police department.
Would the
So,
city's attorney represent us in that case?
no, so
If we were threatened by, in the context of doing our job?
So, yes and no, because the state attorney's office does provide victims advocates, right? Because, there is a whole slew of victims' rights that we have in the state under the Constitution, and that's something that's provided in a different manner. But I would be available to consult because ultimately, my client's always the city, right? And I can represent any of you in the performance of your official duties and actions, but to the extent there's ever a departure, which that would not be an example of a departure from, because it's not your fault, right, that somebody's doing that to you, right? So I think I could provide you to a certain extent that type of representation, but I would rely more heavily on the victims advocates that would be provided through the state attorney's office.
Thank you.
So, if there's any additional questions, all my contact information is there. Yes.
I have one question. I think I know the answer, and it's probably not a problem, but I ask anyway. I work in the elections office as a volunteer, as
that's fine.
a poll worker. So that's not a,
That is not going to be in office, no. So you're absolutely fine with that.
Well, thank you very much, Ms. Kardash, for your excellent presentation, as always.
You're very welcome. It did go a little longer, but I
Okay,
hope
we
it was
forgive you.
informative.
We forgive you.
Thanks.
Any other board comments? Any other staff comments?
Nope.
Well, then it is 7:33, and I adjourn this meeting.
Great job.
Thank you.